All right, that was Wesley Edges. He was the the stepson, excuse me, of the defendant in this case, James Prokopovitz. And he testified in a way that was helpful to both prosecutors and the defense. And I think that is just how every witness in this case has gone so far. Let me bring back in my guest, Jamie White, Wisconsin attorney Jamie White. Jamie, let me ask you this question. Is there a rhyme or reason to how you call your witnesses? And the reason I ask is you get these family members coming on early in a trial, and you would expect that at being early in a trial and being family members, you would get a lot of strong information from them. But I don't think it's working out that way. And does that disappoint a jury such that that can hurt your case?
I think it does. Typically you want to get the things out of the way that are not going to be helpful. We see this more often from the prosecutor's point of view because sometimes there's evidence that just isn't helpful. And I think what we're going to see, depending on how the defense plays this, is law enforcement is going to be used against the prosecuting attorney and probably should have been the first pieces to this puzzle. This case has been going on for years. They searched the entire state of Wisconsin to some degree. I suspect they ran every forensic test that could have been used, whether it was on his truck or his home. We heard some testimony today about searches that took place at quarries and locations where the defendant worked. And so, I suspect what we're going to see from the defense is them meticulously going through every little piece of that investigation and asking them the same question at the end. Did you find anything? Did you find anything? Did you find anything? Ultimately making the case that despite their best efforts, there was absolutely zero forensic evidence to suggest that she was assaulted, killed in any way, shape, or form in that vehicle or that home. And so I do think there's probably a miscue by putting the family up there first, who did bring strong emotion both days, and potentially have the potential for swaying jurors despite what appears to be scant evidence at this point in time.
The defendant is on the witness list. And I'm going to ask you this question, although I know what you're going to say. Is there any chance at all that you would take the chance of putting this guy on the stand?
I would not. Based on what we've heard so far, it's just not necessary. The defense attorney here is skilled, and he's going to be able to educate the jury in closing about their role in this case. The judge is going to pile on with jury instructions, and it just isn't necessary here. I wouldn't rule it out, I suppose. There's always two things that I like to look at when it comes to whether or not a defendant will testify. And one big piece is not whether or not he's telling the truth or not telling the truth. It's really just their ability to present to the jury. And having not spoken to this man personally, that's one factor that is hard to evaluate. So if he was an orator, Barack Obama's level of orator, and could get up there and tell his story, I may consider it. But at this point, no, I think that would be a mistake.
Yeah, I think it's safe to say he's not on that level of oratory.
Yeah, probably.
All right, Jamie, thank you so much for joining me this evening.
My pleasure.
I truly appreciate it. And hopefully, as always, you'll come back and join us again.
Sounds good. Thanks, Michael.
All right. All right, that's going to wrap up our coverage for today. Again, we will pick it up again tomorrow morning, so please join us again as the trial continues.